Okay. Thank you for waiting patiently, everybody. I do apologize. That hearing was scheduled at 2:45 and we just finished, so. This is Concierge Corrections LLC versus Grimes et al., docket number 21-13 CB. This is the time set for two motions. The first one is plaintiff's motion to show cause why defendant Brown should not be held in contempt. And could I first have appearances of counsel, please?
Good afternoon, Your Honor. Jason Canvasser appearing on behalf of the plaintiff, Concierge Corrections.
Your Honor, Mark Merlanti on behalf of defendants Lenny Grimes and Capital Town Investments.
Good afternoon, Your Honor. Darwin here on behalf of Matthew Brown.
All right, thank you. I will say, Mr. Is it Merlanti? Your audio is terrible.
Really? I haven't had that problem before. I'm sorry.
It's very muffled.
I've got the volume all the way up. I'll see what I can do.
Sometimes volume all the way up makes it worse, but that's just a thought.
How's this? Is this any better?
Probably. We'll see.
All right.
I think.
Okay,
maybe.
thank you, Judge.
Okay, you're welcome. So, Mr. Canvasser, this is your motion. You may go ahead.
Thank you, Your Honor. Do you want me to address them together or deal with the independent advisor's motion first?
Well, I guess together would be time efficient.
I'll try to be efficient, Your Honor, because I think the issues are the same. And as you'll recall, we were in front of you in February. We had issued a discovery request to Mr. Brown. We had issued a subpoena to insurance market advisors. I'll call them IMA just for brevity's sake. We didn't get a response from IMA. We didn't get any documents from Mr. Brown. We had a hearing in front of Your Honor, at which point you basically gave the same directive in response to both parties and said, hey, tell us which documents you have, what you did to look for them. If you don't have them, tell us why you don't have them, or if they ever existed, if they were destroyed. You gave a checklist of things that had to happen. We received responses in a timely fashion from Mr. Fair's office. But those responses did not comply with the court's order or the court's directive. And there's a couple troubling facts here, Your Honor. I'll start with IMA. In regards to IMA, the documents were received, the responses were received, were again signed by Mr. Brown in his individual capacity. They didn't indicate his relationship to IMA. He's believed to be an owner, but they were signed personally. He again did not provide us any information relative to IMA's bank accounts. And he again did not provide any information relative to his tax returns, only saying that he's seeking a tax attorney to complete them, which would indicate to me that he hasn't filed tax returns since 2016, which I find hard to believe. But even if that's the case, he has not affirmatively stated, I have not filed tax returns in now going on, 5+ years. But again, no bank accounts, really no material documents here, Your Honor. And IMA is, although they're not a party to the case, is really a central issue because IMA is a predecessor company that Concierge Corrections became an offshoot of. And then they continued to receive these consulting fees and charge lease and take a lot of money from Concierge Corrections and to the tune of hundreds of thousands of dollars, to which they now say, well, we don't have any documents. I'll also note that and this is a continuing theme, there seems to be a bunch of excuses here. The accountant died, the mail was sent to an address that had burned down. Briefly, the address that burnt down, according to well, first of all, there is no address on the news article for the property that burned down, but just for the benefit of, given the benefit of doubt that it's the same property, the stuff was mailed well after that house burned down. So to the extent that there's trying to be an innuendo or some kind of suggestion that these documents were destroyed, I think is a little disingenuous. The mail would have either been at that property, it wouldn't have been destroyed, or would have been returned as undeliverable. And likewise, with the CPA's death, while sad, certainly there had to be people at the office or some kind of succession or something to happen to the client files. Now, in regards to Mr. Brown, personally, this is a little bit more troubling, Your Honor, because Mr. Brown affirmatively states that he had no tax returns, federal, state, or local, going back to 2016. Well, we were able to obtain through Concierge's previous attorney tax returns that Mr. Brown filed for 2016 and 2017. So this isn't a case of I don't have them. I'll let you get them. This is an affirmative representation that they don't exist when we've now found out that they do in fact exist. So that's one of the issues. We also don't know the status of any of the other tax returns. Mr. Brown says repeatedly, you have my authorization to get this stuff. Well, I can't take these discovery requests and go to the IRS, or discovery responses and go to the IRS and say, well, he says I have his authorization. I actually need an authorization form, which he failed to produce. He also failed to produce any information on his bank account. So I can't even go to a bank because I don't know which bank to go to. And then lastly, Your Honor, Mr. Brown makes a comment about certain documents that he had personally for IMA that were sold in an auction on July 26, 2019, as a result of his failure to pay storage fees. Your Honor, the owner of Concierge Corrections, the current owner, Melissa White, confronted Mr. Brown on October 5th, 2018, about all these issues, told him about her exposure, told him that she was hiring counsel, and he had an affirmative duty to preserve evidence. So now we're not only talking about a misrepresentation, I believe we're getting into a spoliation issue as well, Your Honor, for failure to either get those relevant documents out of storage or pay a storage fee so they weren't destroyed. So, Your Honor, we have a plethora of issues, but they all came down to the same basic fact that Mr. Brown and his company IMA are not being cooperative in discovery. They're intentionally hiding information from us, it appears, and it's severely prejudicing plaintiff's ability to pursue this case, Your Honor. And so we've asked for both entities, Mr. Brown and IMA, to be held in contempt. And, we leave it in your discretion to fashion an appropriate remedy, Your Honor, but we view this as highly problematic.
All right, thank you. Mr. Fair?
Well, Your Honor, first of all, let me start off by saying that my client did contact COVID, and he is still recovering from it. And I can tell you now, Judge, it is not the easiest thing of communicating with him because of that. But having said that, let me go through these allegations one at a time. And I will say, from an overview, my client has done everything he can in good faith to comply, to get information that he has at his disposal, and to let me know, the plaintiff's counsel know what the status of the documents that they require. Now, with regards to IMA, Judge, I will not ever say another lawyer is nitpicking, but this issue of how he signed, my client re-signed in their answer to comply, to show how they are, the relationship my client has with IMA. With regards to the bank account, they gave counsel the name of the bank account. The tax returns for IMA, the tax returns are the tax returns. They haven't done the tax returns. He doesn't have tax returns. And, you can't make a person do tax returns. I mean, I've never heard of asking someone for their tax returns. They say they haven't done tax returns, and then they should be held in contempt for not filing their tax returns. That's something between he and his lawyer. That's not my lawyer. And so that is something that, attorney-client privilege of what's going on there. But the reality of it is he hasn't filed any tax returns. Now, if counsel wants to send us, and I can't remember the name of the form, Judge, but, send us the name of that form, we'd be more than happy to fill it out, which allows them to go ask the IRS what tax forms are available for IMA. With regards to the independent contractor, I think we made it pretty clear why IMA and Matt Brown were independent contractors of the plaintiff, because the plaintiff, in all honesty, just wasn't up to the job and needed my client's experience in this area to help her out so she could receive compensation, and he was compensated for that. With regards to the burned down house, Judge, I'm not sure what more to say. The tax returns were sent to the address. The address is the house that was burned down. The CPA is the person who prepared it. And if you look at the date on that document, it was after the house was burnt down. So that was never given to my client. My client's never seen that tax return. My client doesn't know anything about that tax returns and had never seen that tax return until it was sent by the plaintiff's counsel. Now, I'll also add this, Judge. We told counsel that we don't have any tax returns. Instead of him saying, well, I have them, let me send them to you and tell me what you have to say about that. Well, we would have told counsel the same thing we put in our answer is, my client doesn't know anything about it until he got that document. And the date on it made clear that it's occurred down the road in the future from when the tax would normally be filed. And he never gave anybody permission to file any tax returns. Did he give people information? Did he give his staff? Did he give, whoever was helping him with his tax returns to the information? Yes. But was he ever given those tax returns to file? No. And then again, with regards to Brown, the tax returns, I've mentioned about the tax returns. Authorization is a form that I'm not sure what the name of the form is, but if plaintiff counsel knows the name of that form so he can get tax returns from the IRS, we'd be happy to give it to him. We've given him the given the name of the bank. And, my client can't help the fact that he couldn't afford to pay the storage fee and it was sold, and we gave you documentation to that effect. So I don't know how you can blame someone for not, paying storage fees that has the information that the plaintiff wants. I can understand the plaintiff wants information, but if we have it, we'll give it to him. If we don't, we don't. And I will say again that my client, did everything he could to turn over every document that he has. And I will say that, counsel brought up in the first two paragraphs on both motions about why they think they have a strong case. And we did a brief why we think they don't have a strong case. So, if anything, Judge, my client will always do everything they can to give the information to the plaintiff as possible. But in terms of any remedies and where we have today, I just don't know what more my client can do. And, if you hold them in contempt, if you do a show cause why they should be held in contempt, I'm not sure where that gets us in terms of them turning over more documents or records. I told him if he comes up with any other records, let us know. I'll turn them over to plaintiffs. And then the other thing, Judge, again, I'm the last person to say that, that the plaintiff is nitpicking here. But what really concerns me is that we're never going to do enough to satisfy the plaintiff. Never. And we're going to constantly come back before the court. And, that's fine. But, I just don't know what more my client can do to help the plaintiff out give him whatever information he needs. And lastly, I'll just say this last thing is, I just don't know how this information is going to help the plaintiff. You know, my client as the IMA received funds from the plaintiff. There was a legitimate reason for getting the plaintiff, getting the money. But after he gets it, what difference does it make? If you're an employee, you know, and you're paid, who cares how you spent your money that you received? It's your money. And if the plaintiff is saying that they don't deserve the money, well, that's a different issue. But how he spent the money, I just don't see how that helps their case. You know, you can say all day he's not entitled to that amount of money. Fine. Okay. But if he spent his money on a new car, a new house, paying bills, what difference does that make with this case? I just don't see the relevancy. And even with regards to the bank account also, Judge, I mean, you know, he can, you know, counsel can go and subpoena, you know, it says that we should authorize him. Well, I don't know how to authorize the bank to do it. You know, he can subpoena the bank, but we will cooperate and give him anything he wants if he wants to try to go to the bank and get the information. We have nothing to hide there, but again, if he has the information, I don't see how it does anything in furtherance of the case. So I'd ask the court, you know, at the very least, you know, what other document can we possibly get that he says he doesn't have? You can't make people make up documents. And I'd ask the court at the very least, you know, have the party sit down, have a third party sit down with us and just go step by step to see what they need in order for them to be happy, short of constantly come back to this court and having to take up the court's time to go over these issues that, quite frankly, Judge, could be done by a phone call or email. So that's all I have to say, Judge.
Thank you. Mr. Merlanti, please tell me that you don't wish to be heard since this doesn't pertain to your clients.
Well, I just wanted to make a brief comment, Judge, which
Go
is
ahead.
Ms. Grimes is here, my client. This case was filed in 2021 with accusations that Ms. Grimes and Mr. Brown have conspired to divert money to themselves. We've produced reams of discovery. Not a single piece of paper that I'm aware of indicates that Ms. Grimes received any money other than her W-2 paycheck. So I object to the continued general characterization of this scheme between the plural defendants. It's been repeated in both motions by the plaintiff. I understand that was their position when they filed the complaint, but at this point, a year and a half later, they should modify their position to reflect reality. Now, I am all in favor of providing documents. We've been doing that. We've got a discovery request that Mr. Canvasser and I are discussing right now. We will continue those discussions. If the court thinks that there's a third party that can help with discovery, I'm not opposed to that either. But we wanted to state for the record that we object to the continued broad characterizations when there's no evidence to support them going forward with respect to Ms. Grimes, who is a bookkeeper, so that's what I wanted to say. I have no general comment on this motion, Judge.
All right, thank you. Well, the way we got here was because of a previous motion to compel. And I signed and made an order compelling responses and indicating that with respect to these documents, if they were readily available, they had to be provided. If they were not in the defendant Brown, and I'm talking about defendant Brown first, if they were not in his possession, then he had to indicate whether they were ever known to exist, whether they were destroyed, their last known location, what efforts were made to obtain them, and to sign authorizations for the plaintiff to obtain them. In conjunction with that order, there were supplemental responses that were filed, and I have reviewed those, and I would break this request for production down into three categories. There's documents that are being requested that were prepared for or on behalf of plaintiff is the first category. The second category is documents that clearly are the personal documents of defendant Brown. And then the third category, I have to confess, I'm just not clear. It's not clear if the request is asking for something on behalf of plaintiff or something that was a personal document of the defendant Brown. But in any event, with regard to the first category, documents prepared for or on behalf of plaintiff, the defendant Brown responds to those requests by saying he was a consultant only to plaintiff and that he is no longer associated with plaintiff. And then he answers about documents, certain documents he says never existed. So if they never existed, the questions that follow about their last known location and et cetera are inapplicable. Then there's other documents that he says did at one time exist, and he has answered with respect to those. He's answered generally that they would have been retained by the plaintiff, and he has no access to them or authority to access them. Now, it's not for me to judge the truthfulness of that response, but that is his response. And that is an adequate response if he was in fact only a consultant and is no longer associated with plaintiff. If you're going to ask about documents prepared for or on behalf of the plaintiff, his answers are sufficient. However, many of the document requests are clearly requesting what would be the personal documents of defendant Brown. And the first request is number 25 that asks for tax returns from 2016 to the present. Maybe the plaintiff doesn't read the response the way I do, but I read it as saying they're not done. Yes, indeed, he did not file tax returns. You can't produce a tax return you did not file. However, the plaintiff has obtained a 2016 tax return. So there actually was a tax return filed, federal, state, and local, or federal and state at least, I believe, for 2016. So if the defendant Brown has not completed tax returns for 2017 to the present, then he certainly can't produce them. But having said that he didn't do any for 2016, when in fact they exist, casts certainly some doubt. At the very least, he should sign the authorization that authorizes the plaintiff to obtain tax returns, and that way the plaintiff can test the veracity of the claim that no tax returns have been prepared for 2017 to the present. Request number 42 is for copies of your bank statements 2016 to 2018. I think that is clearly a request to defendant Brown, not something that he did on behalf of the plaintiff, but something to defendant Brown. And yet he answers, because I am no longer associated with plaintiff, I cannot obtain the documents. And plaintiff has my authorization to obtain the documents from its bank accounts. That is just intentionally evasive and a non-answer. The request was clearly made regarding the defendant Brown's bank statements. And not only that, defendant Brown was required to provide an authorization directed to his banking institution that would authorize the release of those bank records. And instead, he says, I'm no longer associated with plaintiff and I can't obtain the documents. That's not a good faith response to that request. Number 49 is requesting audit letters from the state of Michigan or the IRS from 2016 to the present. The defendant Brown denies that any ever existed, but then he goes on to treat the question as if it pertained to audit letters sent to the plaintiff. But again, the plaintiff found one, but I agree, it is from 2012. It is not 2016 to the present. So that wouldn't have been responsive. But I'm still not satisfied that defendant Brown has made a good faith answer to that document request, because he's acting as if it is a request for an audit letter received by the plaintiff. And it is not. It is a request for an audit letter received by him. And that's clear because the plaintiff says, hey, look, we found one. And like I said, it's for 2012, but it's to defendant Brown individually. That's what they're asking for. So with respect to those three requests, Mr. Brown's answers are insufficient, they're evasive, and they're incomplete. And they're not made in good faith. Now, the plaintiff has requested, well, they actually requested contempt. The procedure for contempt has not been followed. They also ask that he not be allowed to introduce anything to support his defenses. I presume that these are things that would help the plaintiff and not support a defense. Maybe I'm wrong about that, but I don't think that makes much sense. Or the plaintiff asks for default to be entered. I think that at this point is an extreme remedy that I would be reluctant to grant. I will assess costs, reasonable attorney fees necessitated for plaintiff to bring this motion. And I will order, apparently Mr. Brown has COVID, if I understood Mr. Fair correctly. But I will order that within 21 days, Mr. Brown responds with the signed authorization for the plaintiff to search for any filed tax returns for 2017 to the present, that he respond with authorizations in a form directed to a banking institution that authorizes release of his bank statements from 2016 through 2018. And that he respond appropriately to whether he has received any audit letters from the state of Michigan or the IRS for the years 2016 to the present, without turning it into a question about audit letters sent to the plaintiff, but whether he has any audit letters from those years. And if this being the second time I've had to order this discovery, I will consider default if these very specific things that I have ordered are not done within 21 days. I will consider default as an option with respect to Mr. Brown. Now, with respect to insurance market advisors, the defendant Brown's initial disclosure says that he owned insurance market advisors. So I'm taking that as true. And this is a subpoena, obviously. They're not a party in this case, but the subpoena requested invoices. And yet again, the defendant, Mr. Brown, answering, I guess, individually, but maybe now that's been corrected and on behalf of insurance market advisors, responds to this as if this were invoices issued on behalf of the plaintiff. But the subpoena does not say that. The subpoena requests all tangible and intangible documents, including but not limited to any transaction, invoice, payment, agreement for services, and any other such financial records related to any financial exchange of goods and or services between insurance market providers, DBA provider-friendly network, and any named parties in this suit. So to say that this, to pretend that nothing has been issued on behalf of the plaintiff is evasive in answering this request under the subpoena. Then the rest of it is that they're asking for documents evidencing transactions. Again, the response is to pretend that this is directed to the plaintiff, transactions with the plaintiff, but it includes it includes, as I've indicated, beyond that. So it is not limited to invoices or documents evidencing transactions pertaining to the plaintiff. Documents showing payments received, same situation, and agreements for services, same situation. And by the way, on each of those, documents evidencing transactions, documents showing payments received, and agreements for services, the answer to this is treated as invoices issued by plaintiff. These aren't requesting invoices issued by plaintiff. They're requesting documents evidencing transactions, documents showing payments received, and agreements for services. So, and this would pertain to insurance market advisors. And then finally, the question about tax returns is just completely evasive and not answering the requested documentation, because with respect to whether the documents were ever known by Brown to have existed, he says yes to W-2 personally, no to federal, state, and local tax returns and supporting documents, including without limitation, all K-1s, pay stubs, 1099s from 2016 to the present for IMA. That seems implausible, but that's his answer. But then for the next part of the request, identify whether the documents were destroyed, and if so, when. He answers only for him personally about the tax returns. He says they're not done for me personally, but the question included insurance market advisors, so it doesn't answer the question. And then the next section is I have no knowledge about tax returns for Grimes and or Capital Town Investments, but again, he's not answering with respect to insurance market advisors. So that too is non-responsive. So the request here is for fine, imprisonment, or both, so a contempt kind of request. I would just direct counsel to MCR 3.606, contempt committed outside the presence of the court. This isn't the proper procedural method for getting a contempt contempt committed outside the presence of the court. I will award costs and order that the request be responded to within 21 days. And again, if the tax return situation requires authorizations, that authorizations be signed. But I am awarding costs again to the plaintiff for having to bring this motion when I've already ruled that these things have to be provided, and under what terms the requests for them have to be answered. If you will submit that, Mr. Canvasser.
Your Honor, if I may, we have spent a lot of time with this, and I will say again that, and I'm not asking the court to change its decision, but the only thing I'm concerned about is, like I said, we'll be back here again because a document wasn't presented, a document wasn't signed, and it just seems to me that I'm noticing that my claim is being taken out. I hear co-counsel saying that they are working through these issues. And, if he wants an authorization form, Judge, I have no idea what the authorization form is. I have no idea what it is. So if the court's saying I've got to go figure out what the authorization form is, I will try to figure that out, but I don't know what it is. I know there's an IRS form. I don't know what that form is. Am I supposed to go do the research and find out what that form is? with regards to the bank? Am I supposed to contact the bank and say, what form do you need me to sign so that plaintiff can get the documents, opposed to him just subpoenaing the documents? You know, and
Mr. Fair,
it just, Judge, it just seems.
Mr. Fair,
Oh, I'm sorry.
I think my ruling speaks for itself, and I think it is evident that saying plaintiff is authorized to release these things is completely inappropriate and is no authorization whatsoever. I have cases all the time where people sign authorizations for release of tax returns and release of bank statements. So is it for me to tell you how to figure that out? I don't think it is. It's for me to rule on the plaintiff's motion, and I've done that. Thank you. That will conclude our hearing.
Your Honor, can I ask one clarification? As it relates to cost, did you want me to include a specific number in the draft order?
Yes.
Okay. Is the court issuing a ruling on a specific number?
No, because I can't. You have to tell me what the number is, and then, you know, the defendants might have an objection to reasonableness of hourly rate or reasonable hours. They're entitled to object to that.
Fair enough, Your Honor. I'll propose something.
Judge, can we?
All right, thank you.
Judge, can we